My name is David Newell. I am running for the Court of Criminal Appeals, Place 9. And the reason I'm running is that I've been doing criminal appeals for about 16 years now. And I have a lot of experience in front of the Court of Criminal Appeals. And I've seen the court. I've been studying the court for the last few years. Starting in 2007, I actually have been responsible for the Court of Criminal Appeals update from the State Bar at their Advanced Criminal Law course. I lecture regularly and extensively on the court. I'm board certified in both criminal law and criminal appellate law, which less than 100 people can say that in the state. And we're looking at several different judges stepping down, not the least of which is Judge Kathy Cochran, whose place I'm running to fill. And she's a unique voice on the court. And one of the things that she's a tremendous writer, and one of the things that she brings is a clarity to her opinions that I think that I am equipped to provide because of my strong writing background.
How would you describe what your judicial philosophy would be?
Okay. Well, my judicial philosophy is I'm a constitutional conservative. I believe that the Constitution was designed to enshrine the rights that were given to us by God, and that we should, and that actually comes out of D.C. versus Heller, which Justice Scalia wrote, and I think that really encapsulates it. The idea is that we shouldn't be looking for the Constitution to put rights into it. The Constitution is pretty clear on what it says our rights are, and we should be using judicial restraint and trying to decide things on the most narrow possible ground so that we make sure we protect the liberty of the citizens and provide opportunities for everyone.
Some have alleged that the Court of Criminal Appeals is too prosecutor or too state friendly and has a propensity to dismiss serious prosecutorial misconduct as, quote, harmless error, end quote. Do you agree with this assessment?
Well, you know, that's tough, and I certainly see why people have that assessment, and I certainly, you're exactly right. There are certain examples in your question that have been numerous big profile cases where the court has done just that, and so people can understandably see that and are going to think that's very much the case. What I think you can see, though, is a shift more lately towards an effort to try and make sure that the system is more predictable and fair by going back and granting relief so that we make sure that good evidence is presented to the trial during the trial, so there isn't a need to reverse on appeal, so that the defendant gets all of the evidence that he wants beforehand. An example being Tillman versus State was a case where they excluded defensive evidence on suggestive eyewitness ID, and the Court of Criminal Appeals, known for being pro-prosecution or having a reputation for pro-prosecution, recognized that the evidence should have come in. And there's been a lot of different circumstances where the court has done things just like that. They just don't get as much attention as, understandably, the huge difficulties where you're dealing with a prosecutorial misconduct claim or an exoneration.
Do you think the current court properly vets capital punishment cases?
Well, I know that there's a lot. I could say that there's a lot of effort that goes into it. I think that they have a lot of people looking at those cases, and there's a lot, you know, as far as properly vetting, the procedure requires a direct appeal to the court from a death penalty case, and then also a concurrent writ of habeas corpus. So there's two different examples where that gets taken care of, where the court is looking at the case. And additionally, the elements of the offense and all the law surrounding it really provide a great deal of focus on making sure the case has been properly tried and adjudicated. Not to dismiss the fact, though, that there have been mistakes that have been made, and so that is something that has happened. But the court has been very, very careful to do that. And I would say, too, one of the things that you've seen the court has been trying to recently get away from some of the procedural defaults that might prevent a defendant from raising a claim. For example, the court went back and re-examined and started looking at defendants' writs of habeas corpus on their own initiative under Rule 79.2. And the reason that they did that was because they knew that if they had tried to go through the procedural default route, eventually it was going to waste a lot of time to get to these claims, and they would ultimately have to be considered and found to be meritorious. So the court, on its own initiative, being proactive, decided to make sure that they would get to those claims, and these were claims dealing with jury instructions for death penalty cases. After the Supreme Court in Abdul Kabir and Smith had recognized that certain jury instructions during a period of time in Texas law were inadequate, the court not only recognized that those were going to be bad, but also took it on their own initiative to make sure that those cases went back. So I think that they're really trying very hard to make sure that they vet these cases, maybe more so than they seem to have in the past.
Do you see any opportunities to improve the ethical integrity of the court?
Well, I think that presupposes the idea that the court, lacks ethics or integrity, and I know that the courts are, the different judges are certainly doing their best, and they're trying very, very hard. But I think that the cornerstone of making sure that you restore the perception of ethics and integrity is making sure that you act ethically and with integrity. And I think that if that is the question, then absolutely. I think that bringing my own ethics and integrity to the court will certainly enhance the court as a whole.
Is there anything you can do if you're elected as a judge to expedite the appeals process?
Well, it does seem like these things take a long time, and certainly historically they've taken a lot longer because, when you're talking about death penalty cases especially, because they would do everything in a line. It would be a direct appeal, then a writ of habeas corpus, then a subsequent writ of habeas corpus. It would go through the federal system, then it would come back, things of that nature, and that could tend to drag things out. Then there were some statutes passed that made them concurrent, so that the direct appeal and the writ were concurrent, and so that has helped speed up the process. But the court can also, make sure that it adheres to its own internal deadlines to try and make things move faster. And plus, I think you're going to see, with the recent advent of e-filing, I think you're going to see a lot more efficiency on the court, because everyone is able to file quicker, everyone's able to get the materials quicker, and I think that's going to help a great deal.
I want to thank you for joining us today. How can people find out more about your campaign?
Thanks. Well, if you would like to know more about my campaign, you can go to www.newell, NEWELLFOR, or you can find me on Facebook. Feel free to friend me or like me on Facebook, and I'll be happy to talk to you, and I sure could use your support and your vote and your endorsements.
Thank you.
Thank you.